LAO-TSOI vs. CA and GINA LAO-TSOI, GR number 119190, January 16, 1997. Justice Torres Jr. Topic: Persons and Family Relations, Family Code, Psychological Incapacity. The facts of the case are as follows. Plaintiff and defendant married on May 22, 1988. Despite sleeping in the same bed from May 22, 1988, to March 15, 1989, no sexual intercourse occurred. As a result, they agreed to undergo medical examinations. She was discovered to be healthy, normal, and still a virgin. Her husband's checkup was kept private. The plaintiff says that the defendant is impotent, and a closet gay and that he married her, a Filipino citizen, in order to get or preserve his resident status in the nation, and to publicly present himself as a normal guy. The plaintiff refuses to reconcile with her spouse. The defendant contends that if the marriage is annulled, it is the fault of his wife. He argues that he has no issue because he was discovered not to be impotent, and that any disparities between the two of them can still be addressed. He revealed that they had not had sexual relations since their marriage, till their separation because his wife shunned him. He also stated that his wife brought this action against him because she is concerned of being compelled to return his mother's jewelry, and that the defendant will consummate their marriage. The marriage was found null and void by the trial court. The Court of Appeals upheld the trial court's ruling. The issue here is whether or not the petitioner is psychologically incapacitated. The court held, yes. Persistent unwillingness to consummate the marriage is akin to psychological incapacity. Appellant stated that he had no sexual contact with his wife after nearly 10 months of cohabitation, and it appears that he is not physically disabled. Such unusual refusal or unwillingness to consummate his marriage is highly indicative of a serious personality disorder, which, in the court's opinion, clearly demonstrates an utter insensitivity or inability to give meaning and significance to the marriage under Article 36 of the Family Code.
Petitioner further claims that the respondent court erred in ruling that the purported unwillingness of both the petitioner and the private respondent to have sex with each other establishes both parties' psychological incapacity. However, neither the trial or the respondent courts reached a decision on who, between the petitioner and the private respondent, refuses to have sexual contact with the other. However, there has never been any coitus between them. In any case, because the action to declare the marriage unlawful can be filed by either partner, who refuses to have sex with the other becomes irrelevant. According to the Family Code, one of the essential marital obligations is to procreate children based on the universal principle that procreation of children through sexual cooperation is the basic end of marriage. In the case at hand, one of the parties' nonsensical and persistent refusal to fulfill the above marital obligation is comparable to psychological incapacity. The petition was denied.